My name is Nikki Pressley. I'm the Texas State Director and Chief of Staff for Right on Crime at the Texas Public Policy Foundation. As Vice Chair Cook already kind of outlined, HB17 amended the definition of official misconduct to include a prosecuting attorney's adoption or enforcement of a policy of refusing to prosecute a class or type of crime, and then also added additional safeguards to that petition and investigative process. ROC, Right on Crime, supported HB17 because although we do believe in prosecutorial innovation, there's a difference between an innovative prosecutor and someone who is trying to erode the rule of law. Specifically, we appreciated the language. We believed it had a precise definition of what a non-enforcement policy looks like. It included exceptions for true discretion and diversionary programs, and it enhanced the accountability of prosecutors. I think from what we have seen so far in a couple of the petitions filed, people are able to get into the court and file their petitions, so I think it is working so far. And that pretty much concludes my testimony, unless you would like me to kind of talk about a few other approaches that other states have taken, but sticking to this bill, that concludes my testimony.
I would welcome that.
Okay. So Florida, actually, the governor has the power to remove prosecutors. And Tennessee, the Attorney General has the power to petition the Supreme Court for a district attorney to be removed. And the Supreme Court does an investigation, and if they find that they refuse to prosecute, then they can appoint someone pro tem in that in the replacement. And then Georgia also introduced legislation last session to create a commission that would be the investigative body.
And as part of the broader conversation that we had last session, I think there was I wouldn't say maybe exactly the same as what you just listed from Georgia, but there was a conversation around reconstituting I can't remember the name of the office anymore. It's one of the few things that we've actually sunsetted, maybe one of the only two things we've ever sunsetted. So it was a discussion that was had, and then so the path that the legislature found forward was HB17 through Vice Chairman's leadership. And so I think that is something that we weighed in, kind of waded into how to do this. We have a statute on the books that's been there for some time. Is there a way to kind of utilize that process and bring in a certain conduct that was being concerned? The way that I've always talked about it is as providing blanket clemency, right? We all know that power belongs to the governor alone. And so and I think you hit the nail, when you talk about innovation versus subversion, right? Those are two different things. Innovation is something that we expect our elected leaders to engage in, to understand how to best serve their community. We want to foster that. We want to make sure they have the tools available to do that. We certainly want to curtail subversion, right? Those are the two kind of lanes that I think about this in. And so, I appreciate your comments, and always good to know what other states are doing. But I think that kind of working within the constructs that we had was the most efficient way forward. Members, have any other questions? Yes, Representative Harris.
Thanks, Chair. Hey, thank you, Nikki, for being here. Quick clarifying things. I always do like to learn from the experiences of other states. In the states you mentioned where, one state had the governor can remove a DA, it broadened the category of folks, I guess, petition for the removal. Were they similarly, were the triggers similar to the way HB 17 is constructed, as in, like, could a governor, and I don't know if you said Florida, could the governor remove a DA if that DA had, like HB 17 does, and forgive me if I'm butchering the language here, has a policy or had a professed, category of crimes for which he wasn't going to punish or prosecute? Was it similar triggers that had to be satisfied for a governor to remove or for other people to petition for removal of a DA, or do they have much more broad discretion?
I believe so. It might have been a little broader, but we also have a Florida state director and a Tennessee state director. So if you'd like, I can definitely meet with them, get a little bit more details, and get back to you.
No urgency, but I'd appreciate the clarification. Mm-hmm. Thank you.
No, that'd be helpful if you can supply the committee with that information, just as we kind of delve into the conversation.